issues that IEBC faced before were addressed. So why are we not addressing them? They ought to be addressed.
All right. Let's switch topics and talk about the integrity battle in court right now, and it's still related to the Daily Nation front page. Block these people. EACC tells Chebukati that's the integrity battle in court. There's the fate of 241 aspirants the anti-graft agency once barred from contesting in the August 9th polls over integrity questions hangs in the balance, even as the Electoral Commission yesterday came under increased pressure to strike off their names from the ballot. Okach, from a legal perspective, and I don't want you to wade into this because it's an active case even right now. They were in court yesterday, EACC and IEBC. Has Chapter 6 been abused? Chapter 6 of the Constitution. Do we seem to be flip-flopping with it around? Nobody knows what to do exactly, or nobody even knows what the threshold really is.
Indeed, the issue is that we have two provisions in the Constitution. One that tells us that ideally, if one still has an active case, or if one is still going through the ranks of appeal, then that person cannot be barred. It's very clear in our Constitution. But we also have another provision which tries to tell us that if you have been removed from office through, whichever means, or if there is a decision that has actually found that you are unfit to be in office akin to impeachment, then you are not even eligible to actually vie for any position, from MC all the way up. But despite this, we read the Constitution in terms of the purpose. And the problem that we have is that the framers of this Constitution were very good. They did one of the most progressive constitutions at that time. There are others which have come up, and we are told they are a bit more progressive. Nonetheless, looking at it, you find that the very first test that faced this constitution in reference to Chapter 6 was when the current president and the current deputy president decided to vie, and in 2013 or 2012 per se, going towards 2013. And these questions came up because our Constitution was very fresh. That was when we needed, once a Constitution is there are questions that are taken to court, and the court distills them. And that is why the American Constitution, you won't find a lot of constitutional petitions nowadays, because most of these things were decided, so that there is no gray area. So the moment our Constitution was young, these things will, of course, find themselves in court. And the court ought to, pronounce themselves with finality. In this particular instance, it was clear that once you are faced with such allegations in terms of integrity and probity, of course, anyone will tell you that automatically you do not fit. You are not, you are not fit in respect to Chapter 6. For one reason or another, people now said, if you are faced with crimes against humanity, crimes defined in the Rome Statute, it is even worse. So people thought it was not even a question that, a court should take a day or two to make a determination. What happened? A 5-judge bench actually pronounced itself and said, no, as long as you have not been found guilty, and even if you're found guilty, you still are in the mechanisms of appeal, then you can actually vie. That is where this particular Constitution and Chapter 6 started seeing its death. Gradually, we have found through that, many people have used that and will still use that. And that is why you will find IEBC telling you, and without battling an eyelid, that ideally, they will not actually stop anyone, regardless of Chapter 6. The Chief Justice was very clear on this particular issue. Once you have been convicted, you actually do not qualify in view of Chapter 6. The problem we have is that there are constitutional bodies which are put in place to actually enforce this. And before you actually cleared by IEBC, these constitutional bodies must clear you. In terms of Chapter 6, EACC has a constitutional mandate to actually clear and ensure only people who are clean in terms of Chapter 6 get to be cleared, or they give them even a certificate. EACC now is not even giving you a certificate. Actually, what they did is that they just come up with a list and send to IEBC, then transfer that constitutional mandate to IEBC. They fear pulling that trigger, and they're telling IEBC, you are the guys who should bar these people. That is actually wrong, because they are the ones who should be the gatekeepers of Chapter 6. The moment you start passing that back, IEBC will not do anything. So no matter how many headlines we will have, no matter how many reports EACC will give, IEBC will not bar these people, because that is a constitutional mandate of EACC. So here again we come to look at failure of an institution, which is constitutionally mandated, people who are being paid to safeguard on Chapter 6. Because the moment they decline, and they ought to come up with a system, and we have advised them, they ought to issue clearance certificates, just like DCI issues clearance certificates. And if you do not qualify, they will not issue you with a clearance certificate. Yeah. Are they doing that? They are not doing that. In fact, when you go there, it is just a form that they fill, and they give you and you take to IEBC. Then they expect IEBC to now discharge their own mandate in terms of blocking people. Chebukati is right on this. He has no business blocking people when people have come with documents from EACC, not indicating that they are not qualified. So it's not even an issue of of things not being clear, Trevor. Yeah. Things are crystal clear. It is only that we as Kenyans are used to the old ways. We are used to the old ways that we want someone else to actually do our work, or to actually do the dirty work or the heavy work, and us, we are left with light duties. Yet at the end of the month, you expect a salary from the taxpayer. The people who are actually now failing us on Chapter 6 are the people who are sitting at Integrity Center. Yeah. They do not uphold integrity in this country.
Yeah, and Dennis, are we just involved in a merry-go-round of some sorts? Because we have Chapter 6 that talks about integrity, but you also have the part of the rule of law that you're presumed innocent until proven guilty. And then now EACC and IEBC is locked in this contest where EACC says 241 aspirants have integrity issues, do not clear them. IEBC says we have no business, we are going to clear them anyway, because they're still innocent until proven guilty.
Yes.
Where does this leave Kenyans then now? Are we locked in a game of musical chairs, so to speak, or are we shooting ourselves in the foot?
It's possibly the manner in which we are doing it, and who we are expecting to address the issues, because really asking IEBC to bar politicians who are quote-unquote said to have integrity issues is like throwing a sinner to church and asking the church to reject the sinner, you know? Why? Because the sinner has sovereign rights to access the church. So is the politician. Whether, as long as the law says that if this person hasn't exhausted their rights to a fair hearing and a fair justice system, then you can't tell them anything. And also political participation rights, the right to participate in public affairs, the right to participate in universal suffrage. That person carries those rights entirely and universally, and you can't take that away from them. So is this sinner is in church, the church is supposed to access them these rights and not block the door. However, we have to look at this differently. And how do we look at this differently? If then the law says until they exhaust every avenue, so then we go back to exhausting those avenues. You understand? So we have to look at on matters of corruption, how then can we shorten those avenues? So that those avenues don't necessarily spill over, especially on matters of corruption. They don't spill over to the next electoral year. You understand? So we come back to Parliament. And you know very well that that question may not survive in Parliament, because then politicians are going to know that we'll be targets to this knife that we are sharpening. But we have to look at our judicial process in many other ways. Number one, we cannot go the suicide way of using our criminal justice system for political expediency. We are doing this country a grave injustice when DCI and the judiciary and what is being used to settle political scores, because we set a precedence of unbelievability. Even though the matters may be genuine that are presented, we constantly, the politician will be pulling that card of political expediency. So we have to, I believe that we have to sit in a place where we strengthen arms that fight graft to the point that they have to be used for the right reason whatsoever. And then we now look at legal process and procedures and come up with legal infrastructure that will medicate the time space. You understand? Because really, if the advantage they have is time, they haven't exhausted these mechanisms, then how can we shorten these mechanisms and make sure that these mechanisms don't violate their rights? But then, as long as it's a graft case, why can't we put a timeline of a year? You understand? Because it will just take us to review our constitutional legal infrastructure and then expedient graft issues, so that nobody will have the luxury of saying, I have not been heard fairly, and the criminal justice system, based on graft, does not settle political scores. We have to circumcise it completely off any kind of political manipulation, so that it is almost a religious process that is not subject to manipulation. Because the question of graft is key. If the president told us that we are losing 2 billion a day, that is equal to 700 billion a year, and this country is bleeding consistently, then this is a question that we can't be playing around with.
Yeah.
So my recommendation would be look at the process, shorten the process, so that whatever that we see exhausting those measures, we no longer have that narrative anymore.
Yeah.
And then at the end of the day, depoliticize the criminal justice system, especially when it comes to matters graft.
Yeah.
So when we medicate it in those two thresholds and those two spheres, then we will not be getting ICC that is charged with this mandate, giving an independent, and IBC will just take it as an advisory. It is not a direction, because you cannot direct an independent body.
Yeah.
So IBC is not subject to what EACC says. They will only take it as advisory. Okay, these people have been brought before us, but let us go back to their Bill of Rights. Let us go back to many other things. So IBC in itself cannot violate rights that it's supposed to protect.
Yeah.
So we go back to Parliament, and Parliament must relook at this legal process issue.
Yeah.
And I believe institutions, committees like JLAC, sit in a place where they are able then to ensure that this country doesn't have prolonged graft cases that become subject within electoral processes.
All right. Duncan, what would it take to shorten the time frame, like what Dennis is saying? Because that would save everyone so much drama. I mean, we all know if there's not sufficient evidence throughout the case and the person is let go.
Exactly.
Yeah.
Ideally, that question has been asked, and I believe even the former Chief Justice Emeritus Maraga actually spoke to this and tried to see which mechanisms they can use. Ideally, you cannot have a statute that fast-tracks time, because I remember even Uhuru Kenyatta actually recommended that. But if you try that particular route of having a statute that will fast-track this particular kind of cases, one issue that you'll face is what Thumbi has rightly said. It has to go through Parliament.
Yeah.
Parliament, you find that these parliamentarians will actually be the first victims of such. So it will not see the light of day. Just like
they'll shoot it down.
They'll shoot it down in the morning.
Against them.
So that's the first problem. The second problem is that even if it will pass Parliament and actually be enacted as an act of Parliament, you'd actually find lawyers going to court the next day, and they will say that this is discrimination. You know, even you cannot discriminate. A criminal has rights, a convict has rights. So you cannot just, and a suspect has rights, because at that point someone is a suspect. So you cannot now discriminate on this and say that this is now weightier, or this is more of a crime than maybe a capital offense like murder. Because we've not even institutionalized timeframes for murder cases, capital offenses. So corruption is not a capital offense in terms of its definition. So someone will say, why then will you discriminate? And the suspects in this will actually gang up and pay lawyers very heavily and get the best lawyers, and they will actually shoot it down. The best way, if I am asked, and I always think about it and introspect about this, and I believe if you ask an ordinary Kenyan today, because the Constitution is actually by the people and for the people. And the BBI decision by the Supreme Court still said that the people have the mandate to amend this Constitution. So if we as a country really believe, like Thumbi is saying, that this particular issue is actually a very big issue to all of us, and it's something that we need to deal with, and we do not want to be in this conundrum again come 2027, then it behoves us to, and civil society, to actually look at this particular issue And we try to ask ourselves the question, if you ask your grandmother up country, Dala, if you ask Mama Mboga here, if you ask Nafula there, what will be the view of this particular person? If the answer to this is that, and that is, those are the polls, opinion polls that I would even be expecting to be seeing, is what is the view of the ordinary Mwananchi on this issue? If we get those results and they tell us that majority of Kenyans will support amendment of the Constitution to actually instill and distill timelines, and to an extent even amend and separate these particular crimes, because in other countries, there are crimes even worse. Actually, there are crimes against humanity.
Yeah.
So to a large extent, if Kenyans can actually come to that particular point, we then would actually start a constitutional amendment process whereby we have a referendum and the common person will actually make this decision. This decision will then not be subject to Parliament. It will not be subject to me or you. It will actually come to be the law of the land, the supreme law of the land.
Okay.
With that, I'm telling you, we will never have this issue. No one will even want to sit next to someone who is corrupt, because you feel that it will actually have adverse effects on you. So a constitutional amendment is actually the panacea to this issue.
Okay.
Without that, I'm telling you, the Constitution, the way it is, the Bill of Rights, if you look at Article 81, the principles of voting, what Tumbi is saying is right. You cannot then just decide to bar someone just on account of this.
Okay.
Just shortly, I think one of the ways that we have to look at every political office holder is we have to treat them under concepts of transient law. As an occupant, you know, it's like you're paying rent in a house that is not yours. And I believe that we need to get to the place where in that nature of application, and I'm just talking conceptually, in that we have to let politicians know that there are certain rights that you may not behold of them eternally. For example, if there's an issue of graft, we will take you through a different process more than we take anybody else.
Yeah.
As long as you're a public servant, we will treat you in a different measure than we treat everybody else. Because corruption in itself is not different to mass murder. You understand? And because you are disempowering the community and the country on its strength to produce life, strong people, treat their people, raise up strong kids. You know, the dignity of life in itself is robbed from the aspect of graft.
Yeah.
So it's to me it's a violation of every human right whatsoever, and it is a brute force that a leader would, expose the public towards. So we have to apply transit law and tell them, look, you are paying rent in that office, even though we are paying you. So as a tenant would be to a landlord, there are certain rights that are accessed to you by virtue of you being a Kenyan in the Bill of Rights.
Yeah.
But because of where you sit and the sensitivity of what you do towards the nation and towards the people, there's a certain manner that we will deal with you on issues of graft or misuse of power or anything whatsoever, that we may not take that route to a citizen. And I think we need to find those ways. Whether those ways sound unfair or not, because there's no fairness when you steal money. There's no fairness when you're a thief. There is no fairness when you put your hand into public coffers and you take medicine that is meant for COVID patients who are dying, or school children, or whatever it is that there is. It doesn't matter where you dip your hand. You've dipped your hand in you and you've compromised the quality of life in this country.
Yeah.
So this is a critical conversation. And if Parliament would not then adopt this posture in terms of reviewing the law to suit the fight in terms of graft, then I believe perhaps in the near future, then if it means us going the Article 1 where it says that people can exercise power, directly, I mean, through referendums and those kind of utensils, then I believe that we have to go that way, because we can't be singing this choir and this song of graft every day and every year without finding a solution.
Okay, let's switch topics and now talk about the 12th Parliament. It has come to an end, but let's bring up your feedback first of all before we move into that topic. 12th Parliament has come to an end. We'd like to know what your thoughts are in terms of their performance now. Agumba Steve says IEBC should take responsibility for anything and tell us how, when, and who brought the mess. We are in a digital world and able to trace each step in interfering with the register issues. Otherwise, they'll plunge into electorate mistrusts. Okay? Let's see what else you're saying here. Mogire Jasper says, I don't like the sound of this register thing this close to the election. This is something IEBC could have done administratively before and 2017. Are they going to remove or in fact add voters? What do they actually do then that day by day? Okay. Timo Kanda says, as to whether candidates having integrity issues should be allowed to vie or not, the presumption of innocence should be allowed to prevail, period. Okay. See what else is going on here. LJ Sindani says, one of the panelists describes our constitution as very progressive. What is progressive about a self-defeating constitution? Constitution provision of IEBC as an independent commission can only make sense if we have independent staff. Okay? See what else you're saying here. Engineer Lazaro says, the law is very clear. IEBC to clean the register on time and open it to the public scrutiny before election. Let us give the space and time. Okay? Let's see what else you're saying here on Twitter before we move into the 12th Parliament that is just adjourned Sinadie or Sindai, depending on which school you went to. Malela, if EACC, Kenya and IEBC can't bar aspirants with integrity issues, why should they exist? We can't ask Kenyans to vote out corrupt leaders when we have bodies charged with enforcement of Chapter 6. Okay? Let's see what else you're saying here. On Atanas Mavuti says, a credible election starts from an accurate voter register. With IEBC had 5 good years to prepare, yet within 2 months to the election, there are still errors in the register. Mr. Chebukati and team should know that choices have consequences. All right. Let's talk about the 12th Parliament now. It has come to an end. Yesterday it was adjourned there indefinitely. Of course, they can still be recalled for any special sitting there. They still stay as MPs until the 9th of August, actually, when the election happens. They can still be called for a special sitting, but for now, they've adjourned indefinitely. And Dumbi, I'll start with you on this one. What is your rating of the performance of the 12th Parliament in general? How have they performed?
Wow. I am personally disappointed by the 12th Parliament for various things, especially the very fact that they failed to protect the doctrine of the separation of powers. I don't think in a new constitution that spells the independence of the various arms of government, we have ever seen a violent takeover like what happened within the 12th Parliament, you know. And they then serviced the directions and the whims and the desires of the executive. You understand? They played